Who's joining. We are going to begin in just a few seconds here as we give folks just another moment or two to join. Okay. Well, I want to say good afternoon to everybody who's joining us today. My name is Paul Burns. I'm the Executive Director of the Vermont Public Interest Research Group, or VPIRG. It's my pleasure to welcome you to today's Candidate Forum. Our co-hosts for this forum are the ACLU of Vermont and Vermont NEA. Our honored guests this afternoon are the two candidates running in the Democratic primary for Attorney General, Vermont's top law enforcement office. I'll let them introduce themselves in just a moment, but first I'll just briefly cover some of the housekeeping notes and describe the format for this 1-hour event. Closed captioning is available at the bottom of your Zoom window. We ask that all participants mute themselves when they're not speaking to minimize the background noise. Each candidate will have 2 minutes to introduce themselves, and then we'll have representatives of the co-hosting organizations ask questions of the candidates who will have 90 seconds to answer. As time allows, we also plan a short round of brief questions and answers, and to wrap up, each candidate will have 1 minute for closing statements. We will alternate who answers the question first throughout the forum. And to keep on track, the candidates will see a countdown timer, and that clock will let them know when time is running out. And so we urge the candidates to keep an eye on that. Otherwise, we will provide a friendly time check. Since this is just a 1-hour forum, we have questions from the 3 co-hosting organizations. We do not have the Q&A feature on Zoom enabled. However, we do have the chat open, and attendees and campaign staff are free to share sidebar information there if they choose. Co-hosting organizations will also be posting links to relevant information in the chat as we go along. We're live streaming and recording this forum, and it will be posted for viewing afterward. If you have any tech issues, please message VPIRG or post in the chat. Finally, with those as our ground rules, it is my privilege to introduce our candidates. And first, I'd like to go to Charity Clark. Charity, would you please introduce yourself and your campaign, please?
Yes, hi, thank you, Paul, for having this forum. It's great to be here. My story begins in southern Vermont, where I grew up working in my family's grocery store. I worked my first day when I was 10, and my last day when I was in law school. I stocked shelves, I ran the cash register, and during that time, I saw all kinds of people coming through the store, people thriving, people struggling, people working. And when I grew up and I became a lawyer, I took those experiences with me. Especially these last 8 years working in the Attorney General's office. These last 4 years, I have served as chief of staff, and I was a member of the leadership team. I was a part of decisions made on every major issue our office faced, whether it be environmental, consumer, criminal. And I, in leading the office, always remembered that everyday Vermonter I encountered as a child growing up working in my family's store. I believe what we need in Vermont is an attorney general who understands the scope and breadth of the office, who knows how to leverage the office for the best results across 7 divisions. And I believe we need a leader who knows how to meet this moment in history. Here are my priorities. 1, protect consumers and small businesses. 2, global warming is the existential crisis of our time. We need an attorney general who will be an enthusiastic partner to the state in enacting the policies laid out in the Vermont Climate Action Plan. 3, prioritize public safety and criminal justice reform so that our criminal justice system is aligned with our values here in Vermont. And finally, as the first woman elected Attorney General, I will place a renewed focus on issues related to violence against women, including reproductive rights, domestic violence, and sexual violence. Thanks so much for having me today.
Thank you very much. Appreciate it. And Rory Thibault, please introduce yourself.
Good afternoon. I'm Rory Thibault, and I'm joining you from Cabot today. First, I want to say thank you to VPIRG, the ACLU, and NEA, one, for putting on this forum, and also for your leadership in your respective fields. So my story right now is really centered on the town of Cabot. I live here with my wife, Joanna, and my 2 sons, River and Cody. Many people may know me as the Washington County State's Attorney, but there's a lot more. I am a father, I'm a youth sports coach, a sometimes farmer, and I am the chair of the Cabot School Board. Each of these positions and roles gives me a view into the lives of Vermonters and keep me embedded and attached to the communities that I'm serving. My professional career began when I graduated law school in 2007. Joanna and I set out on an 8.5-year journey of active duty service for me in the United States Army, where I served as a public defender, as a prosecutor, and then as an international and operational law attorney. That diverse set of experiences enshrined me with leadership skills and a breadth of knowledge beyond just criminal law, which many have come to associate my career with. I have devoted my life to public service and want to continue serving the public as the next Attorney General. As Charity mentioned, we are at a historic crossroads. We have a hostile Supreme Court and a hostile federal judiciary, and Vermonters have for a long time been able to rely upon the Supreme Court as the ultimate expander and defender of individual rights and freedoms. We can no longer make that assumption. So we need to be prepared to move forward aggressively to defend Vermont values outside of the state. But right here in Vermont, there are several priorities I'd like to mention. First and foremost, I believe I have the experience and expertise to bring about a truly 21st century criminal justice system, one that is rooted in empathy, equity, and transparency, integrating harm reduction strategies, sentence reform, and any other number of opportunities to change how we do things. We also need to be good stewards of the environment and be mindful that the legal decisions have impact on the climate crisis. We also need to ensure we defend fundamental freedoms. And finally, we need to ensure that public safety remains a paramount priority for all of government.
Thanks so much. I really appreciate the introductions, and now we'll move to the first set of questions. I will ask 3 questions on behalf of VPIRG. The first will go to Rory Thibault, and you'll have 90 seconds to answer. State legislators recently enacted a state code of ethics for the first time, but they failed to empower the Ethics Commission with any investigative or enforcement authority. With the support of the governor, legislators had earlier taken away the public's ability to request an advisory opinion of the commission. How would you describe the state's actions on ethics, and what steps would you recommend moving forward?
So first and foremost, I think we at least made some progress in this session. I'm very glad to see that the Government Operations Committee was able to advance a bill. But that being said, a term I heard a lot coming out of Montpelier this year from media outlets and others was that bills were watered down before they got across the finish line. And I think we have a lot of progress to make up for on ethics. First, a lot of the state's current ethics regime is based around the EB-5 scandal. And I think we still don't have the complete picture of the failures, acts, and omissions of government officials in leading about the largest fraud perpetuated upon Vermont in history. So with that darkness in terms of what systems need the greatest reform, I think that the steps made this year were a good first step. Just as you identified, though, having the ability of the public to request advisory opinions or have those made available, or being able to request an investigation is critical to ensuring a system that is accountable and transparent. I'll also note that coming from the federal and military system, when you look at the federal government, whether it's the joint travel regulation or the joint ethics regulation that exists, they are much more robust and deal with scenarios that we still don't have answers to in Vermont. Things like, how do you take gifts from people in state government? What do you do if you're approached by a lobbyist or an outside interest? How do you interact with that? How do you avoid conflicts of interest? There is a robust set of questions that need to be answered. And I think that we would be best served by having an ethics commission and regimen that is completely empowered to make sure that Vermont government officials act with integrity and on behalf of Vermonters.
Thanks very much. Charity Clark, your response to that question?
Thanks. I'm really glad that that bill passed. I testified on that bill in support of that bill. It's really important that we hold ourselves accountable and also create a model for us to follow. It's very easy, I think, in Vermont to feel that we're just an ethical place, and we're so lucky to have close proximity to our elected leaders. To government, we have direct democracy living strong in Vermont, and it's easy to overlook the importance of an ethics code. And I'm glad that we have taken the step we have. I should also note that, of course, attorneys in the Attorney General's office adhere to their own code of ethics, the rules of professional responsibility, which are overlapping with the code of ethics. So this is a great first step. I agree that it will be good to reflect pretty quickly on how this code is working and to see if more can be done. I think it's good that we did this, and it's also good to be monitoring. I would look for a report, an accounting to see how things are going, and also what the public's perception is in how things are going. So this was great that we did this, and I think that we should very quickly be monitoring and seeing how things are going to see if any adjustments need to be made.
Thanks very much. Here's the second question, and this will go first to Charity Clark. In recent years, Vermont has taken steps to protect consumer data and limit the proliferation and misuse of sensitive personal information. For instance, establishing the first data broker registry in the country and enacting legislation to prevent educational software companies from selling and using student data for non-educational purposes. Vermont has, however, stopped short of enacting the more comprehensive consumer digital privacy legislation that we've seen enacted in states like California, Colorado, Virginia, and Utah. Do you believe that Vermont should do more to enhance consumer privacy? If so, what? And how, as Attorney General, would you use your office to advocate and enforce those protections? Charity Clark.
This is an issue that's incredibly important to me. I think I mentioned this issue in my kickoff when I announced I was running for Attorney General. For 4 years as Chief of Staff, I led our office's work on data privacy. And some of the bills and steps that you just mentioned are things that I advocated for personally. I feel very strongly that although we have really been a leader in this space on many fronts, we need a comprehensive data privacy law that will touch on many issues we haven't quite gotten to yet. Other states have, and they are a model for us about a better way forward. And I would just highlight a couple of those items. One would be data minimization, which is enacted in California. Two would be using the data broker registry to not only have data brokers disclose when they allowed for an opt-out, but required them to allow for an opt-out so that consumers could decide, I don't want to be tracked. I don't want my data to be sold. And finally, a biometric data bill that would regulate the collection and use of biometric information, similar to Illinois, which has a private right of action. I believe very strongly about this. I personally, wrote the memo to the legislature advocating for this in January, and I very much am looking forward to them taking it up this January.
Thanks very much. And Rory Tebow, your response to that question.
So I think one of the core values I see a lot of Vermonters exercise is a huge interest in privacy. We may be very communal and socially based in our small towns around the state, but there's still a degree of privacy. And I think that needs to extend to digital privacy. One area that particularly concerns me, and I think we need immediate legislative action, is adding and bolstering our protections around health data. We already have robust measures in place when a doctor or an insurer or a hospital collects data on a patient. And likewise, being what it is with long-term quarantines and a lot of people seeking health information on their own, we need to make sure that protected health information cannot be resold, protecting it at much the same level that educational data has been. This is also incredibly important in light of the Dobbs decision and the recognition that Vermont may soon be a safe harbor state for women and those with the uterus seeking to exercise reproductive liberties or providers seeking refuge in Vermont from a hostile jurisdiction. Going beyond that, I'll note that during my military service, I was living in the European Union in Germany, and I got used to the data collection and data privacy systems there, which are more robust than what we see in the United States, whether it's internet tracking and cookies through web browsers and activity and applications, or just generally a better regard for not monetizing every aspect of a consumer's preferences and purchases. What I'd ultimately like to see Vermont get to are protections that are as comprehensive as what we see in jurisdictions like California and Colorado. And I think in the long term, we ought to be looking towards a system that is based on opting in for data collection rather than having to opt out.
Thank you very much for your response. And there's one more question from me before you hear from others. I promise I won't dominate this whole thing, but this last one is on climate. You've both signaled a commitment to the Global Warming Solutions Act, which legally requires climate pollution reduction in line with the Paris Climate Accord. please explain what concrete steps you would take as Attorney General to ensure that Vermont meets its legal and arguably our moral obligation to act on the climate crisis. Rory Thibault, you're up first.
Thank you. So I think one of the most important steps the Attorney General's office can take right now is being more aggressive in putting out advisory opinions to state government to ensure that other agencies that are not directly controlled or served by the Attorney General are aware of the consequences of inaction. Whether that's ANR, the Agency of Agriculture, there are any number of agencies in government that have a huge role to play in meeting these goals and yet are not always they're really served by political appointees in the administration and may not be aligned with where the legislature's at or where the Attorney General is at. So I think making sure that the consequences are widely known and put out well in advance of failure is important to make sure that our administrative partners are doing the right thing. I think I've said before, one of the things that worries me the most is having to be in a position as the Attorney General to defend the state's inaction or failure in meeting climate goals, and having to litigate against Vermonters who share values. And yet it is the role, unfortunately, of the Attorney General to defend the state, even when the state is the bad actor in the equation. That's something that I really dwell on, and it concerns me of how to get there. So in the meantime, the best way to avoid an unfortunate situation such as that is to be aggressive in working with legislative partners and with the administration to make sure that we are not just giving lip service to climate change and these goals, but in fact, taking the legally required steps to change. And quite frankly, I feel like we are behind the curve, and the time is now to speed up.
Thank you. And Charity Clark, your response.
Thanks. I want to begin by saying climate change is so important to Vermonters, and global warming is a concern we all have. It's a crisis we all have. As Chief of Staff, I led the Attorney General's office's work on the Global Warming Solutions Act, and especially supporting and defending accusations that it was unconstitutional. When the governor vetoed that bill, it was me who led the work on assisting the legislature in overriding that veto. I am very proud of that work. And I'm also very, very proud of the work that, that has been done by the Climate Council. And if anyone listening hasn't looked at the Climate Action Plan, it is really wonderful. It's a comprehensive plan to follow. We just have to do what they say, right? The Attorney General's office plays a really important role in supporting the legislature. They have their own lawyers, but we have a lot of deep expertise on constitutional law and on environmental law. As Attorney General, I will support the legislature using those attorneys. I also want to point out, I was involved in the clean heat standard work this past session and was very disappointed when that failed to make it across the finish line. I think we got to pick that up in January. That'll be a big priority in January. And the other thing, we need an Attorney General who has bold leadership and can think creatively about moving the needle on this. I have the expertise in consumer law. We sued the fossil fuel companies on a greenwashing theory. And I think we need that kind of leader at this moment in time.
Thanks very much, both of you. And now I want to invite Jay Diaz, the General Counsel for ACLU of Vermont, to ask several questions. Jay?
Thank you, Paul, and thank you both for being with us. I want to start with an issue that has been close to the ACLU for many years, but particularly in the past year, and that's qualified immunity. And by the way, if you have trouble hearing me at all, just let me know. Qualified immunity, as you both know, is a court-made doctrine that prevents liability for government officials or employees when they violate someone's constitutional rights, unless it's clear, usually based on a prior court case, that those rights were well established. This means basically that a court can say, yes, there was harm, but no foul. So my question to you is it fair that individuals who are physically and emotionally harmed by the violation of their rights at the hands of police, for instance, receive no compensation due to qualified immunity because a similar case hasn't happened before? And in addition, whether you support or oppose maintaining qualified immunity, how would you address the core imbalance at play? And this one goes first to...
Rory is up first.
Okay.
So there's quite a lot to unpack in that question. I'll just start with saying that I think eliminating qualified immunity really would not be the most effective way to address law enforcement accountability or to change behavior. And to take a step back, I think the important distinction and confusion I continue to hear is that people think qualified immunity serves as a bar for criminal liability or other paths of dealing with officer misconduct, including decertification. I think it's also important to note that Vermont did make progress and has progress based upon the court decision in the matter of Zulo, which expanded qualified immunity for Vermonters, or I guess the opposite, which allows a broader path to bring civil suit than is allowed in federal court. I think that's an important distinction. Where I'd like to see Vermont focus is really on officer accountability. Right now, I think Act 56, which was passed in 2017, began a process of giving the training council the ability to decertify, and yet there are still major infractions that can't result in decertification on a first offense, including the exercise of sexual harassment or bias in policing. I don't think that's where Vermont is at, and I think we need to have a better means of getting officers decertified. There should be a clear path of recommendations coming from a state's attorney or the attorney general to do so, not just relying on the council's own exercise of discretion. Likewise, when it comes to accountability, that begins with also allowing for local municipalities to better regulate what they're dealing with. Again, I'm not for the repeal of qualified immunity because I think that just passes the buck on to taxpayers rather than holding officers accountable.
And Charity Clark, your response as well.
Let me begin by saying that I believe in police accountability. It's really important. We are at a reckoning point in our state and in our country on policing systems. And I think it's a good thing that we're taking the time to reflect and say, is this the best system we have? Should adjustments be made? And with qualified immunity, we saw this session take up qualified immunity and direct legislative counsel to create a legal memo looking at the issue and what it might look like here in Vermont. And I look forward in January to revisiting qualified immunity and seeing what we should be doing here in Vermont. Let me say that I believe it's really important to drive systemic change, to hold, regardless of how you treat the individuals, to hold the agencies accountable. The agencies must be held accountable for training, compliance, oversight, to drive systemic change. I think that is the ingredient that drives systemic change, is making sure that we're holding those agencies and systems accountable so that we can have the ethos in Vermont of transparency, accountability, and all of it. We need to make sure that we are holding those agencies accountable. And of course, people who have been wrong deserve an avenue to hold folks account and to obtain a settlement if appropriate.
Thank you both. I'm going to move on to, I think, something that you're both familiar with as well, which is racial disparities in the criminal justice system. And for right now, we're going to keep it to traffic stops. Police traffic stops, for those who don't know, across Vermont have shown persistent racial disparities in stops and in searches of Black drivers in particular, while those same Black drivers are less likely than white drivers to be found with any contraband. We also see significant racial disparities in, for instance, who is imprisoned for drug crime, among other things. How will you, as the AG, address racial disparities in the criminal legal system? And we'll start with Charity Clark.
Discrimination has no place in Vermont, and this is a very concerning issue that we all should be concerned about. Because it affects all of us. It's bad for the whole system, for our feeling of everyone belongs, everyone should feel safe, be treated equally. And it's not working if we have these racial disparities, and we do. We're very fortunate that we in Vermont have gone through this process, the justice reinvestment process. And that was the Council of State Governments. We got a grant, and they used data-based, evidence-based policy making. And they provided, using the stakeholder model, so a lot of us were involved with that, recommendations for the state. And we need to follow the recommendations. First, sentencing guidelines for judges is a good thing. And the other that's really important is data collection. What we found is that in Vermont, we don't collect enough data so that can drive legislation, policy changes, and the rest of it. In the Attorney General's office, when that report came down, we looked internally, especially at our court diversion and pretrial services agency. And I spoke with them personally and said, hey, we need to make sure that we're collecting all the data that we should be collecting. And following that report is a great way to start moving the needle on this issue. It's unacceptable that we have these disparities. And I'm glad that we have that report to tell us what are some great ideas for next steps.
Thank you. And Rory Tebow.
Thank you, Jen. I really appreciate the question. And I just want to note that this is our fourth debate, and this is the first time we've been expressly asked about racial disparities. So it's about time. And I don't think there's no really bigger issue in the criminal justice system at this moment. We each have a role to play, whether it's prosecutors, judges, defense counsel. And in addressing that problem, there are some systemic things that need to change. I was incredibly disappointed when the governor vetoed H505, which started as a bill geared towards raising the threshold for personal use amounts, or the misdemeanor felony threshold for certain drugs. I think that unto itself begins to address disparities and is consistent with the council and state government's recommendations, 1 of 5, on how to better, I think, reduce disparities for people of color in Vermont. That has implications when traffic stops, of how aggressive officers are trying to enforce things. And it also inherently limits what outcomes are available to a court, which adding controls like that, I think, is critical. Ultimately, it's very easy to state words. Actions are harder and they take commitment. The immediate reforms on racial disparities need to be first, as the Attorney General, advocating for the adoption of all 5 of the CSG recommendations, including prosecutorial standards. One other thing I wanted to shift to was Charity's reference to sentencing guidelines. That's a position that even the Defender General's office has been reluctant to go to, because it could, in the federal system, it can sometimes stifle the downward departure of judges and avoid or preclude parties from reaching the most just outcome at a lower level of disposition. So we need to fully fund diversion and restorative justice and avoid hard lines.
Thank you both. And I have one more question for this round, and then we'll move on to Don. And the previous Attorney General, T.J. Donovan, was a strong advocate in the legislature for reduced prison sentences. You both just referenced this, related to drug possession in particular. And his office advocated for decriminalizing low-level possession of drugs, instead promoting public health solutions. This is, of course, amidst an overdose crisis. So we're seeing Impact Vermont. It's the worst it's ever been in Vermont and around the country. How will you, as Attorney General, approach the overdose crisis, low-level drug possession, and decriminalization? And we'll start with Rory Tebow.
So again, a lot to unpack in the questions, but I want to start with this, that moving forward, Vermont's response to drug crime needs to be centered on harm reduction. Harm reduction takes many different paths. First and foremost, it entails changing the system to put more people into, either keeping people out of the criminal justice system altogether, or if they do enter, putting them on a rehabilitative track. That can include treatment court, and it can certainly include the existing Tamarack and court diversion programs. But again, those programs need to be fully funded and resourced. And right now, there is disparity around the state of how well those programs are keeping up with capacity and meeting the needs of Vermonters. There's been a lot of discussion as well about overdose prevention sites and whether that is the solution. What I see is that, yes, there is a place for overdose prevention sites as part of an overall harm reduction strategy in the state of Vermont. It's unlikely to work in every community, may be very difficult or impossible to implement in rural communities. But for the communities that are willing and able to do so, we need to make sure that they are given the proper legal advice and understand how to navigate a very tricky topic so that we're not exposing individuals to liability, including those in the healthcare profession. Looking at the broader scope of harm reduction, I think there are a few things that we could do relatively immediately in the next legislative session. Right now, as you may be aware, most misdemeanor offenses are presumptively to be sent to diversion. In the case of drug crimes, along with the defelonization we talked about earlier, personal use amounts, requiring evidence to be put on why a case shouldn't be sent to diversion as opposed to just a presumption, I think would be more helpful in ensuring those cases end up being disposed at the lowest possible level and not in the traditional incarcerative system.
Thank you. And Charity Clark, your response.
First, let me say that I think it's worth acknowledging that no one in Vermont has been untouched by the opioid crisis. All of us have a friend, a neighbor, a family member, or ourselves who have been directly impacted, who has struggled with substance use disorder and has been impacted. 210 people overdosed last year. On the campaign trail, I have met with mothers who lost their children to opioid use disorder and an overdose, and it's devastating. So to do nothing is not an option. It's important that we all are coming together and thinking about ways to solve this. What we have is a war on drugs that for 50 years has failed. And we need to be thinking creatively about what we can do better. What I think we need to do is move away from a punitive model to a treatment model. To do that, we need to have the treatment infrastructure. As Attorney General, I would advocate and support bumping out our treatment infrastructure, which is inadequate at this moment in time. I think it's really important that that be said. Yes, it's a financial investment and it needs to happen because it's also a financial loss to have so many people who are struggling right now. I think without the wraparound services, decriminalization, depending on what it looks like exactly, is going to struggle. I mean, the whole idea is that we have the decriminalization and treatment together. They need to go together in my mind, and want to emphasize that the importance of the treatment infrastructure.
Thank you both. I'll pass it off to Don.
Thank you, Jay, and thank you both for being here. The June decision by the U.S. Supreme Court in the Carson v. Macon case requiring states such as Vermont that allow public funds to be used at private schools must now be allowed to be used to pay for religious education. The decision will have a significant effect on our public education system and Vermont's 150-year history of using public funds to educate students in private schools. Additionally, the effect of the decision appears to be in direct conflict with the Vermont state constitution prohibiting public money from supporting religious institutions. Unless Vermont changes its education laws, the Carson decision will require Vermont to use public funds to provide some Vermonters with a religious education in schools that discriminate against students and parents based upon their religious beliefs and other protected classes. Vermont law already allows communities that do not operate a public school to designate up to 3 public schools to serve their students. What do you believe the state of Vermont should do to respond to the Carson v. Macon decision? And do you support public education fund money flowing to private schools that discriminate against students? Finally, if public dollars do continue to flow to private schools, should those schools be required to follow all the same rules and laws as public schools, not only regarding discrimination, but also regarding open enrollment, special education services, and educator licensure? And we'll begin with Charity Clark.
I have watched closely this spring, waiting for this decision to come down. It came down the way that I expected it would. Obviously, our system here in Vermont is not dissimilar from that in Maine, and it affects us. I began my career working in the governor's office as a policy analyst, and the main issue that I had assigned to me was education. So for 4 years, I was swimming in education policy. It's really important to me, and I currently serve on the board of my high school in Southern Vermont. I believe there's no place for discrimination in our school system. We have so much to be proud of. And my whole life I've been bragging about this because of my experience working in the governor's office and knowing this. We have one of the best education systems in the country. We are always near the top with testing. People really believe in our schools. Part of the reason why they work is we don't discriminate against people. That includes LGBTQ folks and people with disabilities. It's really, really important that the legislature, now that we have clarity on what the Supreme Court was going to say about Carson v. Macon, respond with legislation to ensure that our dollars are not going somewhere that is out of step with our values in terms of, education being accessible to all people, regardless of whether they're LGBTQ, disability, or any other reason. It's also really important that we are thinking not just of students and their parents, but of teachers. It's really, really important the legislature act in January. As Attorney General, I will support that work.
Thank you. Roy Thibault.
Thank you. Well, 2 things I want everyone listening to know are that first and foremost, I'm a fierce advocate for public education in the state of Vermont. And second, I strongly believe that our public education dollars should be governed by public standards, and Vermont education dollars have no place underwriting hate, bigotry, or discrimination. With that said, I'm the chair of the Cabot School Board, so this is an especially poignant issue for us. We're a district that has sometimes been looked at to be a choice or a sending district. So this is a real conversation that we have to have about where our dollars go and what that means for our children and our families here in Cabot. The decision is, I think, a disgrace in terms of breaking down the traditional separation between church and state. And the Attorney General's office, along with the legislature, needs to be bold and decisive in making sure that those dollars stop going to places where they can harm families or harm children. We shouldn't have a child denied equal access to education because he or she is in a wheelchair or has a developmental disability. We shouldn't be treating a class of children differently because they identify as because they're gender nonconforming or identify as a gender differently than that assigned at birth. We shouldn't be discriminating based upon households that have an LGBTQIA head of household. These are all concerns that strike at the heart of what it means to be a Vermonter and our long history of defending the rights of others. So this is an across the board, all hands on deck effort of government ahead, of litigating as hard as we can in court to uphold those values and ensuring the legislature takes the decisive action needed to protect all Vermonters.
Thank you. Paul?
Don, I did want to just offer you the opportunity. I know you had a lot of packed into kind of one question with multiple parts. If you had a follow-up or if you felt like that was important, I wanted to just make sure that you had that opportunity as well.
Oh, thank you, Paul. Yes, I think I would like to just follow up by reiterating the last part of my question. And that is, if public dollars do continue to flow to private schools, should those schools be required to follow all the same rules and laws as public schools? Start with Charity Clark.
I'm a little hesitant to say yes, since I don't have a list of all of the laws, not to be overly lawyerly about it. I will emphasize, I think the focus on Carson v. Macon has been in the issue of discrimination. And I certainly don't think that public dollars should be flowing to private schools that discriminate on any basis. It's totally unacceptable. And we need to act swiftly to prevent that from happening.
Well, a specific rule would be regarding open enrollment, to not exclude any students, to provide special education services, and to require all educators to have the appropriate licensure as they do in public schools.
I definitely agree in the open enrollment question. I admit I don't know as much about the requirements to be a teacher. So it sounds good, but I wouldn't want to commit without understanding better. That's not an issue I've encountered before at the Attorney General's office in my work.
Thanks. Rory Thibault?
Well, I'll just reiterate, I think public dollars, public governance, public standards is the standard. If the school is going to open its doors and be soliciting public dollars, then they need to play by the rules that we've set for our own school system across the board. No ifs, ands, or buts. We can't allow there to be two different classes of education systems in Vermont. There's a huge equity issue here, and I think it again strikes at the core of the Common Benefits Clause and what Brigham is even based upon of when we talk about equity in education. You know, at the ground level, there should be the same educational quality standards for public or for public schools and for private or independent schools. And you know, ultimately, I'm concerned that because the administration controls the State Board of Education appointments, and we've had a Republican governor in office now for 6 years, that some on that board lean heavily on favoring or looking for ways to support independent schools. I think that's a huge problem. And again, the Agency of Education has its own counsel who are separate from the Attorney General's office that are behind most of our educational policies. So this is one of those areas where I see there could be a very significant conflict between the next Attorney General and the administration. But where I lie is making sure, again, public dollars, public standards.
Thank you very much. Paul?
Thanks, all. And so for this next round, we're moving to, I don't know if you call it lightning, but shorter answers. And so we're not giving you a clock, but and they're probably not one word, but several sentences or a little shorter. We're just trying to get to cover some more ground here. So let me begin. Do you support the use of ranked choice voting for federal races and the presidential primary in Vermont? And Rory Thibault, we'll start with you.
So I think that's, we'll call it around lightning and a little bit of a thunder. Yeah, so short answer is yes. And the one thing I would note, just having heard from my Secretary of State candidate friends, giving a little bit of deference to allowing for that to maybe be done at the state level before we apply it to federal elections, so we get it right.
And Charity Clark.
I'm also a yes.
That's brief. Thank you both. The next question, I've got three, and then we're going to move over to Jay again. The Public Utility Commission's obstruction of renewable energy siting has been a key barrier to meeting our climate pollution reduction requirements. What would you do, or what steps might you take as Attorney General to address this broken system? And here we start with Charity Clark.
We have good relationships at the Attorney General's Office Environmental Division with the PUC. I think we need to be doing more, and getting, moving a needle on global warming involves expanding our reach. And I do think we need to be working with our friends at the PUC to make sure that there are changes put in place that would allow, more involvement from our office, and I would support that.
Thank you both. And the third question for me on this round is, as you know,
I didn't give an answer on that yet. I'm sorry.
Oh, I'm very sorry, Rory. Please go right
No,
ahead.
that's okay. Yeah, no, I don't want to fast forward too much, but I, to give you a brief answer to that, my concern is that it's not always friends at the PUC, and it's not always the PUC making decisions I think are consistent with what Vermonters want. And I'll give credit where it's due to the executive director of Renewable Energy Vermont, said it shouldn't be easier to build a Dollar General than a solar array. And I agree firmly with that. And there are times where the AG's office should seek to intervene in PUC actions.
Thanks very much. As you know, in other states, attorneys general serve as the consumer advocate on energy issues. Should the Vermont AG play a larger role in this space than they traditionally have? And Rory Thibault, we start with you.
I think yes, there's a lot that's going to change in the landscape of rates for electricity in Vermont as we continually move towards a more electrified state, whether that's in our transportation mix or appliances. We need to make sure that the changes are not underwritten on the backs of Vermont's working class and working poor. So yes.
Thank you. And Charity Clark.
As I've said, I really believe that global warming is the existential crisis of our time, and we have targets that need to be met under the Global Warming Solutions Act. There's a role for the Attorney General to play in that space, and I think we need to be thinking creatively and doing everything we can, including being and advocating on the energy issue with regard to pricing and also placement.
Thanks very much. And now I want to invite Jay to ask a few more questions.
Thank you, Paul. I'll start off with a big topic, but it's one that the Attorney General can have a lot of impact in especially in terms of leadership. How will you, as Attorney General, lead Vermont in using the legal system to address poverty? And we'll start with Charity Clark.
90 seconds, is that all I have? So here's what in my view, the very most important and main area where the Attorney General intersects with Vermonters is at the Consumer Assistance Program. I supervise the Consumer Assistance Program these past 4 years. I just remember this is a short answer, so let me be briefer. A lot of the issues that we see at the Consumer Assistance Program relate to poverty. I'm going to give one example: propane. The Attorney General regulates propane, and we enforce our propane law, which is a consumer protection law. When someone is on propane, for heat, it more likely means that they're in a rural area and might be struggling with poverty. It's incredibly important that we have advocates who are knowledgeable and who can fight for those consumers to make sure that they get heat. That's just one example. There's many others, but I think the Consumer Assistance Program is a really powerful tool in helping Vermonters who are struggling with poverty and moving the needle on making sure that they're taken care of.
And Rory Thibault, your response.
Thank you. So I take a slightly different path, and not to undermine the value of consumer protections, but I think what really speaks to changing poverty and what's within the purview of the Attorney General is adopting policies and supporting practices that don't keep people in the rut of poverty when they intersect with the criminal justice system, whether that's supporting sealing and expungement or looking at post-conviction relief to help people out when they've been ill-served by the justice system. As Washington County State's Attorney, one thing I've done is try to de-emphasize the use of fines. I think fines just put people in a hole that they can never climb back out of, which has all kinds of consequences for rehabilitating their record. And likewise, poverty is something that every avenue of state government needs to deal with. And right now, I see DCF staff, among others, that are really struggling on the front lines to bring quality services. We have a mental health worker crisis. We have a nursing crisis. These frontline workers need to be empowered and given the resources, tools, and authority to do their best work.
Thank you. And a little bit of a follow-up here, and this can be more of a lightning round answer, question and answer, hopefully. Will you, as Attorney General, take the lead, as the previous Attorney General did, on holding expungement clinics throughout the state and forgiveness clinics for fine-based license suspensions? Rory Tebow, please start with you.
Yes, and I think that it should be something available every day. And right now, a program run and directed by the Attorney General's office is the court diversion program. There's no reason why we can't cross-train that staff to be available on a drop-in basis for individuals to seek and get the assistance they need for a sealing or expungement petition or for reinstatement.
Thank you. And Charity Clark.
Yes, I actually supervised for the past 2 years the expungement clinics done at the Attorney General's office, personally trained every single lawyer at the office to be able to assist with expungement clinics. I think they're incredibly important. They allow people to move on with their lives, get better jobs. I really, really believe in that work. We were supported by the Community Justice Division that oversees the pretrial services and court diversion program. Really, really believe strongly in expungements. Can't say enough good stuff about it.
Thank you both. I'm going to ask a couple questions, or I ask a question about bail next. So, as you both know, after an arrest, wrongful or not, a person's ability to leave and return home to fight charges at times depends upon their access to money. That's because in many circumstances, people are required to pay cash bail to secure their freedom. And bail was originally designed to ensure that people would return to court, but we have certain services such as, pretrial services was mentioned, text message reminders, transportation supports that can help with that purpose. And the money bail system in some ways really can ensure that a person ensures this wealth-based discrimination and wealth-based incarceration. Those who have money can get out, and those who don't have to wait until their case is adjudicated. So tell us what you think about eliminating cash bail as a whole, and then I'll have a follow-up question as well. And we'll start with Charity Clark.
I would like to see Vermont move from the cash bail system to like a risk-based system. I think that is a better way to be. I believe that we would have to amend our constitution in order to do that. I'm all for it. I think that's what we should do.
Rory Tebow.
So this isn't a question where I think experience matters. So right now, bail is imposed based upon the court's analysis of risk of flight or non-appearance. So there is a risk analysis, there's statutory criteria, there are other common law factors the court considers. In Washington County, we tend to use bail as a matter of last resort and generally not the first time someone appears. But there has to be some recourse when someone repeatedly does not come to court and thwarts justice and leaves victims in the air. So I'd like to see enhancements in ways to protect or limit the use of bail, including enshrining people held on nominal bail with the same speedy trial rights that we give to those held without bail, for example, under Section 7553A of the criminal statute for serious crimes.
And a short follow-up. In 2018, Vermont passed a law that created a maximum amount for bail of certain expungible misdemeanor crimes. It capped it at $200. Would you support or encourage other states' attorneys to issue requests for money bail in those instances? And Rory Tebow, we'll start with you.
So I think that's already generally happening in broad pockets of the state. Some states' attorneys, as you're aware, have been more bold on that. Others have reserved more discretion. Some are more traditional. Ultimately, it's the court that decides, and it's the court's decision. And there are still cases, for example, in Chittenden County, where that office does not request bail, where the court will do it anyway because it assesses that there is a risk of flight. And again, there's a lot of considerations that go into that. What I'm concerned about are the horror stories I've heard of people sitting on nominal $200 bail for sometimes 90 or 100 days before their public defender calls them or before they have a new court hearing. That's unacceptable. And that's where I think we need to focus our efforts immediately.
And Charity Clark.
Yeah, I think you're seeing a lot of agreement on this issue. We're both Democrats, so not surprising there. I think the answer to your question is yes, but definitely feel strongly that the system we have isn't working and needs to change.
Thank you. Paul, I know I've taken some extra time. I don't, happy if you or Don want to ask some questions before closing statements.
I have at least one more here. And Jay, do you have another question if we have an extra minute or two?
Sure.
Oh, I bet you do. All right, well, let me get one more in here and then we'll see what we have time. We'll try to finish right up at an hour. So in environmental settlements, I'd like to ask both candidates, how important is it in your mind to require a corporate wrongdoer, a polluter, to admit guilt instead of simply paying a fine? And it's almost more of a philosophical question for you, to the extent that you can address it as such. And obviously facts matter and so forth, but do you have a thought about that approach to these environmental settlements? I have lost track of who should go first. Does anybody remember? Let me, all right, so Rory, I'm going to go to you because you're first on my screen. Apologies.
No worries. So I would liken this to decisions I have to make every day in criminal court. Do you accept a no contest plea, or do you have a downward departure of a charge just, to reach an outcome? And at the end of the day, I think I'm a person who wants to be outcome based. What gives the best outcome? If the state can get a positive settlement that makes a real difference for Vermonters' lives without the admission of guilt, then that might be a path we should take. Holding out for the absolute, guilt or admission can sometimes be the detriment of positive we could bring to the state.
Thanks very much. And Charity Clark.
I was an assistant attorney general for 8 years, including the time I was chief of staff. But I can tell you that oftentimes parties who are looking to engage in a settlement with the state won't settle if they have to admit to guilt. What we do is we have them admit to the facts as outlined in the settlement agreement. And I think that it's a good solution to make sure the settlement occurs and we don't have to take the case all the way to trial. And it does allow some of that reckoning that is due by just saying, yes, we agree that these are the facts, but we're not going to actually agree to guilt. So I would continue that practice in situations where it was not feasible to procure a settlement without it, in order to avoid having to take the case to trial and basically spend taxpayer dollars doing that instead of just getting the settlement and moving on and getting the outcome that we needed.
Thanks very much. Jay, let me bring it back to you for another question, and then I think we'll go to closing statements from the candidates.
Great, and I want to thank VPIRG for their leadership in hosting this debate and inviting us in the NEA. So the last question I'll ask is on transparency. The AG's office is really the fulcrum point for public records access for state entities. So how will you work to ensure access to public records, increase access to public records, and hopefully reduce public records litigation, which both overburdens the AG's office and the state and reduces transparency? And we'll start with Charity Clark.
I believe strongly in transparency. I think it's not only really important, it's an expectation that Vermonters have because we're so close to our elected officials in government. I like to say we've all kind of run into Bernie Sanders on Church Street or wherever. And, we are used to that proximity to our elected leaders. Public records are really important, and they can create some tension in the Attorney General's office because we have a lot of records that are privileged by the attorney-client privilege. The attorney-client privilege is a privilege that's owned by the client. Our client sometimes is the Attorney General, him or herself, but often it's an agency within state government or the governor's office, and the privilege belongs to them and not us. So we can't just waive the privilege if they don't want us to. That said, there is a lot we can be doing with transparency. So with public records, one, I would ensure that we continue the practice of posting public records responses, requests, and correspondence about those requests on the website so that people would have the benefit of seeing anytime a public document was requested and sent to the requester, it would be accessible. The second is I would create a public records officer for state government. And that person would set policy, because right now we see a difference in approaches among all of the departments and agencies. And I think it would be a good thing for Vermont if we had one person who was setting policy. That person could also hear the appeals that were needed when a department declined to provide records due to an exemption and there was an appeal sought. The last thing I would do is I think it's time for the legislature to look at the Public Records Act to see where opportunities are to modernize it. Right now, it hasn't been looked at in 20 years. And it really imagines a world that we don't live in anymore, a world of paper, for example. And I think it's time that we sort of look at how records are being produced and why they're being produced that fits 2022 and not 2003 or whenever it was last revised. So those are three things I would do. Want to emphasize how important transparency is for sure.
Thank you. And Rory Thibault, your response.
In hearing the response, I find myself questioning a little bit that my opponent was the chief of staff and handled the issue of records in the office. And while these are great ideas, I'm not sure why they were not then implemented in the past. I think the past administration does not have a great record on transparency. I think in addition to the statewide ombudsman that was contemplated, there needs to be a chief information officer inside of the office with a viewpoint of bringing transparency to the decision-making process and leaning heavily on other state actors or internally on disclosing more. And there are any number of cases where I think Vermonters don't have answers that they want.
Thank you both. I'll hand it to Paul.
Yes, thanks very much to both of our candidates. I want to now move to the 1-minute closing statements. And Rory Thibault, you are up first.
Well, again, thank you so much to the hosts. It's been a real pleasure to join you today and some great questions. Vermont is in a really interesting time period, whether it's dealing with issues with the federal government or dealing with issues right here in Vermont. What I think we're ready for, though, is a proactive attorney general, one who has the skill set, experience in court, and depth of relationship in the communities to really affect change. It's not just a function of knowing the office and the 7 divisions. It's a function of knowing Vermonters and knowing the issues that they fail and how the legal tools available at the Attorney General's office can be best brought to bear. When I go to work, I want to be making sure the decisions that we are reaching are for the benefit of Vermont's workers, for our kids at school, and ultimately making sure that as the chief law enforcement officer in the state, that we have a law enforcement system that can be trusted and that can protect the public, whether it's the threat of school shootings or gun violence in communities, or dealing with the trafficking of fentanyl and firearms through the state. There are real public safety challenges that we need a leader with the depth of experience in public safety to handle. I thank you again so much.
Thank you. And Charity Clark, closing statement from you, please.
Thanks for having me. Really appreciate it. I believe that we need a leader who has a vision that is informed by experience and understanding of the breadth and scope of the office. My vision for the office is informed by my experience as an assistant attorney general, as chief of staff, as a mom, and in my upbringing, growing up in Southern Vermont. I want to be the lawyer to the people. I want to fight for consumers. I want to fight for small businesses. I want to fight for families. I want to fight for Vermonters. I believe strongly that as a member of the leadership team these past 4 years, I have that understanding of the scope and breadth of the office. And I will know how to leverage that office to bring about the best results for many of these issues that I have already led on, including expungements, consumer protection, global warming, and all of these important issues. I have the experience, the breadth, the relationships to start hitting the ground running on day one. Thanks again for having me.
Well, again, my thanks to our candidates today. We appreciate your time, your viewpoints, and your commitment to Vermont. It is not easy to run for office, and I really, really appreciate not only your being here today, but putting yourselves out there. I also want to thank our co-hosting organizations, ACLU of Vermont and Vermont NEA, and of course, VPIRG, and everyone who attended the forum this afternoon. Finally, we encourage everyone, of course, to participate and to vote in this primary election. Contact your clerk if you need to find out the most convenient way for you to participate. Of course, primary day is August 9th, but you can vote before that. And with that, thank you once again. Everybody have a great day. Much appreciation.